Good morning, everyone. Thank you for tuning in for our webinar this morning. We're going to be talking about the latest executive order from the state of Michigan pertaining to business operations and whether your business may maintain its operations and also who can be traveling around the state and other things about the stay-at-home order. We appreciate you joining us on this Monday morning, and I have some esteemed colleagues here with me. I'll give everybody an opportunity to say hello. We've got Jim Peterson, Rebecca Strauss, and Steve van Stempvoort on the line.
Good morning.
Good morning. Yeah, good morning, everyone.
Good morning.
And I'm Amy Murphy. So Jim, Steve, and myself are all litigators at Miller Johnson, and we've asked our colleague Rebecca to join us to field any employment questions that might come up as we're discussing this new executive order. We tend to get a lot of employment or issues that sort of cross into the employment sector. So as those questions come up, we'll do our best to answer them as well, and Rebecca may hit on some of them at the end of our webinar. So we're going to be talking to you today about Executive Order 2020-42. That is the latest stay-at-home order from the state of Michigan. Governor Whitmer issued that order on April 9th, and it went into effect at 11:59 on April 9th. That was last Thursday. Just before that, on Tuesday, April 7th, the legislature agreed to extend the state of emergency through April 30th. And with that, Governor Whitmer then extended her stay-at-home order through April 30th. So we'll talk about some of the changes that result from this new stay-at-home order. And we'll also talk about some of the things that have stayed the same and, issues that pertain to your business. And we'll talk a little bit about issues that also pertain to your individual right to travel as well. And we'll also be hitting on some activity that's going on in the legislature. There's a bipartisan task force that's coming up with recommendations about which sorts of businesses can maintain or could reopen under the executive order. We will talk about that. We'll also discuss enforcement trends that we've been hearing about recently. And then toward the end, our colleague Rebecca will field some of the employment law questions that have come in either before this webinar commenced, or if you have questions that you check in with us on using that Q&A feature, we'll be monitoring those. So feel free to use the Q&A to ask us questions along the way. So let's get started. Executive Order 2020-42 has some things that remain the same from the last stay-at-home order. Steve, could you run through what sorts of things going on in this new order are the same for businesses as they were under the old order?
Yeah, sure. Thanks, Amy. And again, great to be with everyone, and thanks for taking the time and effort to participate in this. So, one of the things about this particular executive order is that it did not change as much as perhaps some folks expected. That it's, I guess, good for continuity, but I know that there has been some pushback on that. But regardless, the minimum basic operations designations, those have remained the same, and so that provision, which allows every company to designate particular workers who are necessary to maintain their inventory, maintain security of their premises, those designations that can still occur. So that has not changed. On the critical infrastructure side, and again, this is the big one that everybody's spent a lot of time thinking about. Again, there has not been a lot of change here. There were, the Department of Homeland Security guidelines that were updated by the federal government, the SISA guidelines, we've been calling them. The initial version came out on March 19 this year, and then there was an amended version about a week and a half later. There were some thought that Governor Whitmer's order may adopt the updated CISA guidelines, which are a little bit more permissive, but that did not happen. Governor Whitmer's order, the most recent executive order here, number 42, it specifically says that no, we're going to stick with the earlier CISA guidance. And so a lot of the designations, the definitions of which sectors are critical, that stuff is going to be the same in large part. And then there are some changes. She added a couple of different things, but those, in the big picture, the big definitions of critical infrastructure sectors, the guidance that we're relying on from the federal government, that has remained unchanged.
Thanks, Steve. Jim, are there any changes, are there any additions to the critical infrastructure sectors? Did Governor Whitmer's newest order increase the number of businesses that can arguably fit within the definition of critical infrastructure?
Yes, the new executive order did that in a couple different areas. So, and it was interesting because these were specified in the order itself, including automobile dealerships being allowed to conduct online or virtual sales, and then also hotels being allowed to operate laundromats, coin laundries, dry cleaners, and then made it specific that workers at retail stores that sell groceries, medical supplies, products necessary to maintain safety, sanitation, and basic operation of residences. And so identified some of those as well. And some of that was based on, I think, the frequently asked questions section of the government website, where some of these workers had been singled out in those answers, and now it's just made explicit in the terms of the executive order.
So if your business, Jim, maybe you weren't certain that your business was critical under the order as it was originally issued back on March 23rd and went into effect, I think, on the 24th. But now, based on that FAQ page and the subsequent order that we're now all focused on, your business does meet the definition of, a business that employs critical infrastructure workers. What do you need to be doing at this point?
Well, so and law enforcement takes the same position, right? I think they first want people to read the executive order, read the FAQs, and then use that in order to make a determination. Now, the executive order also links to the federal CISA guidance, and so it's helpful to read that as well. But because I think there is not a lot of clarity in a lot of this, that it also helps to contact your lawyer and talk through some of these issues, because there are a lot of gray areas in this. The Michigan Attorney General has acknowledged that there are gray areas and that this is difficult to interpret, and we've seen some of that with law enforcement as well.
Steve, question for you. I know that the old order, which was number 21, that the older stay-at-home order required a business to make certain designations in writing. Does that requirement carry through to this new stay-at-home order, and what do businesses need to be doing in that respect?
Yeah, so the for a business that falls within a critical infrastructure sector, they do have to make written designations of their employees, which they have to designate which of their employees are necessary for them to continue their critical infrastructure operations. So yes, those have to be in writing. There has been some clarification from the governor, and a lot of the clarification seems to be coming through these FAQs that are posted online. They're certainly not comprehensive, and sometimes they're not altogether incredibly clear either. However, they do give a little bit of guidance, and so that guidance does suggest that the written designation of your employees, you can do that by posting it on a website. You can do it, via an email. It doesn't have to be a formal document, but there has to be some sort of written designation of your employees. And then as far as the other designations, so under the previous order, number 21, under that order, a company could designate its suppliers as critical or not critical. As critical, you wouldn't have to designate them as not critical. So you'd have to deliver a written designation to your supplier, and then the supplier could then rely upon that written designation to continue its operations and make its own designations. That requirement has been changed. So under 42, under Executive Order number 42, which is the one we're operating under now, we don't need to designate your suppliers anymore. And if you are a supplier of a critical infrastructure entity, you no longer need to rely upon a formal written designation. Instead, you can, as a supplier, you can self-designate. You can say, I know that I supply to XYZ critical infrastructure company, and then designate your own workers as critical infrastructure to the extent that they are necessary to support or enable your operations in that regard. So that is a change. There's a little bit less paperwork here under the revised or the extended order than there was previously.
Okay, well, that's very helpful. What about businesses that have been up to speed on this, reviewing the Executive Order number 21, the old one, and already made their designations of workers who are critical infrastructure workers or workers who support the minimum basic operations of the business? Does the new order require any issuing of new letters, new designations?
It does not.
Well, I was going to push that back to you, Amy, because I don't believe that there's been any substantive change really here in folks who have been designated as critical infrastructure under the prior order. But I don't know what your experience has been with the clients you've worked with.
Yeah, I've spoken with some clients on this and let them know that the new order doesn't suggest that you need to make any change. If you've already designated employees who are supporting your critical infrastructure work or your minimum basic operations, those designations continue to be effective. There's certainly no harm in drawing up a new one and identifying the new executive order and the new date that it went into effect, but I don't think it's necessary. Do you agree, Jim?
I do, yes, and it's interesting because those designations at one point in time when law enforcement was first trying to sort out how to enforce the terms of this executive order, they were requiring or telling employees, I want to see your designation. Since that time, the government website first did a FAQ and said workers are not required to carry with them those designations, and now that's also made explicit in the new order.
Jim, one good question we've gotten on the Q&A is about designations that maybe you already have in place. Those designations maybe referred to the old order and were dated by March 31st because the old order suggested those designations needed to be in place by March 31st. So one of our listeners asked, do we need to be, dating new designations to reference that March 31st date?
I don't think that that's going to be required, but there's certainly nothing wrong with doing that. And maybe Rebecca wants to weigh in on this because it does involve some employee relations issues, at least. It seems to me that sometimes it's helpful for your workforce to have a new designation that maybe is a little bit more detailed in its rationale why they're being designated. Rebecca, do you want to weigh in on that?
Yeah, thanks, Jim. Before you mentioned that, I was actually making notes for myself when I was going to raise this at the end of the webinar. From an employee relations point of view, I think folks should strongly consider issuing updated communication. It doesn't have to be one of these formal designation letters because, as my colleagues just mentioned, a new designation letter is not required by the EO. But let's face it, it's been a few weeks and the world has changed. I feel like it changes every day. And the issue now is encouraging your employees to still come to work, right? There's financial incentives, there's very generous unemployment available right now. For instance, folks are feeling a lot of social pressure not to leave their homes. So how do we encourage employees to come to work when we really need them to be at work? Employees who feel safe and secure and like their employers are on top of this and doing everything they can to maintain a safe work environment will be more likely to come to work. You should also consider not just telling them in a very formalistic legal way, which you did when you first designated them, which was appropriate, that they're critical infrastructure workers. Now you may want to shift to the kind of dialogue as to why we are critical infrastructure workers, why the community needs us right now, why our neighbors and friends are counting on us to continue coming to work. We've been drafting letters like that for clients, right? So it goes beyond the designation and is much more of an employee relations issue. So explaining the importance of their work to their organization and to the community, and then talking about all the measures that the employer has taken to keep them safe.
Thanks, Rebecca. Amy, you dealt with that issue too on behalf of some clients. How did you address it?
One thing that we've done is work with our clients on developing a placard that could be posted in a facility of a business that's continuing its operations. And along the lines of what Rebecca has just been saying, the placard gives a kind of a plain English explanation for why the business is operating and why these workers are critical, serving a critical need of the community, and try to not only give them a little comfort that the business is doing all it can to keep them safe, but also motivating them to continue coming to work, because the important work they're doing is not just important for the business, it's truly important for some critical supply chain that, our community and maybe even a wider community, in some cases a nationwide community, is depending on. And that placard can also spell out the steps that the business is taking to keep the workplace safe and keep workers safe and healthy to the extent they can. A lot of those measures line up with what both the old executive order and this newest stay-at-home order identify, which are, the sorts of things we've been talking about on previous webinars, restricting the number of workers on the premises to those who are strictly necessary for the critical infrastructure work or the minimum basic operations, promoting remote work and keeping people 6 feet apart, all of the social distancing measures that everyone's very familiar with at this point. And those placards, I think, can go a long way to keeping your employees apprised of the decision you're making. Certainly, communication with your employees is key right now for all the reasons Rebecca mentioned. And while we're on that topic, actually, or no, go ahead, Steve, and then I'll jump in.
No, I was just going to follow up on that and kind of segue to the supplier issue. And I wonder if any of you guys have thoughts on this, because, sometimes the supply chains are disrupted by whether, an individual supplier or a customer has designated themselves as critical infrastructure or whether they're still open. And sometimes we have clients who they themselves are operating because they are in critical infrastructure, but then one of their suppliers decides to cease operations for whatever reason. And I guess I'm curious, does the same principle about, communications, communicating with your suppliers, communicating with your customers, does that apply within that sector as well, to try to, maintain communication with your, economic partners, the folks that you are supplying or being supplied by in order to try to work out any sort of disruptions in the supply chain? I'm curious about what you guys have discovered with your interactions with clients.
I think there's no doubt that communication with economic partners is, the same counsel carries through here, that if you are depending on certain companies to supply to you to stay in business, it really would be wise to stay in good communication with them and understand the decisions they're making about whether they're going to stay open, so that you can talk with them about, how important their supply is to your business and work around any disruptions if they do happen. Jim, what do you think?
Yeah, I agree with that. When I've talked with clients about these issues, right, I've stressed the importance of communication, and for suppliers who have been designated as critical to support the services of a customer, for them, I've said generally you're not required to second guess that designation or look behind it. I think you can, in good faith, rely upon that unless it's obvious that they're abusing the designation authority. But I have also talked with clients who have been designated and they want to second guess that, and they prefer for it might be employee safety reasons or public health reasons more generally, but they've said we are, despite the fact that we have been designated, we are not going to be continuing in-person operations.
Yeah, and when a company makes that determination, if you know your supplier is going to close operations, but you think that they meet the definition of critical infrastructure and can continue to operate, that would be the time to talk with your legal team, I think, and analyze what's the best way to move forward, knowing that there's going to be disruption to your supply chain and the sorts of contract issues that are going to come up.
Right. I know that's already happened, at least on the east side of the state. I know that one lawsuit was filed in the manufacturing sector where someone refused to operate and the customer sued, seeking injunctive relief. I'm not sure that that's been decided yet, that case has been decided, at least on a preliminary matter. But, we do expect that there will be these kinds of disputes between customers and their suppliers who are making different decisions about whether to operate.
Rebecca, we'd like to get your take on a new requirement in the executive order. As we were mentioning earlier, the previous executive order and this one have some steps that they're requiring businesses to take, social distancing practices and other measures for mitigating the risk of transmission of the virus. And many of those requirements, like maintaining 6 feet of distance between workers and patrons, facility cleaning, and many of them are the same, have carried over to the new order. But there is a new requirement that businesses who maintain operations need to develop a type of plan. Could you talk a little bit about that requirement and what businesses should be thinking through?
Yes, happy to, Amy. Thank you. The new executive order at paragraph 10 does add a requirement that was not part of the old executive order, and it requires businesses and operations that continue in-person work to develop a COVID-19 preparedness and response plan. Now, we've talked with many of you over the last few weeks. We know many of you have such a plan, although it might not be written down, right? Because you've been putting out fires for the past few weeks. But now you are required to have a written plan. It needs to be consistent with the OSHA guidance on COVID-19 preparedness and response. And the plan has to be available at company headquarters or the work site. I would also recommend having it available online. Tomorrow at 8 o'clock, Miller Johnson is devoting an entire webinar to this topic. Frankly, it's a little, it's too much for me to go over right now if we want to get to any of the other aspects of the EO. So for those of you that are continuing in-person operations, please tune in tomorrow at 8 o'clock to go through all the nuts and bolts of what that plan must include. I'll give you kind of the 10,000-foot view here for those of you that are really curious and just can't wait until tomorrow. A few guidelines. First of all, the plans must be specific based on level of risk, and OSHA divides all in-person operations into 4 different levels of risk, and then there is different protective gear required, different types of preventative measures, et cetera, based on the level of risk that your employees will face. It also needs to be specific to your specific business within a certain level of risk, because obviously mitigation measures are going to be very different, right, depending on whether you're an insurance business versus a manufacturing operation, right? So there is not going to be a one-size-fits-all, although there are certain minimum elements that each plan has to include. All plans should include things like promoting frequent hand washing, encouraging employees to stay home if they're sick, encouraging something, frankly, I'd never heard of this phrase before, so we will add it to the things we have learned since COVID-19 became an issue. They are encouraging respiratory etiquette. So that's a new phrase, kind of like social distancing that none of us used before, but now we're going to start using it. Respiratory etiquette, which is things like covering your coughs and sneezes. Employers should provide tissues and trash cans for customers and for employees. Consider establishing flexible work hours to allow less people in the facility at any given time. All the physical distancing that should have been already required anyway. It just now all has to be in a written plan. OSHA would also like you to discourage employees from using each other's equipment to the extent that is possible. Employers should be regularly cleaning and disinfecting, right, whenever possible. And you should be encouraging employees to self-monitor any symptoms of COVID-19, and then, of course, asking them not to work if they are sick or have symptoms. So that is, again, just the 10,000-foot view. There's lots more detail here. I can tell you that, again, just in talking with many of you over the last few weeks, many of you have thought through these things and have implemented most of them. So we do not think this new requirement in the EO is going to upend your organization, but what we do know is that now it has to be in writing, right, and available for employees. And circling back to what I said a few minutes ago, that's probably not a bad idea for your employees to see all of this in writing and know that you're prepared and that you're on top of it.
That's a good point, Rebecca. I just want to amplify that from the standpoint of some of the other things that we've talked to clients about, and that is the importance of documenting your decisions and your deliberative process, because to the extent that there is ever enforcement activity or someone second-guessing decisions, we think it will be important to have number one, gone through the due diligence and the deliberative process to make good faith determinations, and then secondly, to have that documented just in the event there ever is enforcement activity or any disputes arising out of the decisions and designations that employers have made.
I would want to follow up on that and echo Jim's point about documentation. Obviously, communication with your employees is very important for a variety of reasons, as mentioned by Rebecca. Documentation is also an excellent way of being prepared for any eventuality of law enforcement activity. Even entities that are operating fully within critical infrastructure, clearly no question that they should be operating. There have been sometimes they have had complaints or questions, and our clients have already seen that being able to point to documentation has really facilitated a very quick and efficient resolution of any such inquiries. And it's been very, very helpful to them to be able to just say, look, here's our decision, here's the rationale for our decision, and that has proved to be very effective at answering any sort of questions or inquiries that law enforcement may have had.
I was just telling a client this morning the same thing, Steve, that having the documentation in place basically just proves your work and proves that you're taking the executive order seriously, and that that communicates something to law enforcement that sometimes isn't easy to communicate as easily in a face-to-face interaction. One more question on designations before we move on. I know we want to talk at least briefly about the requirements that the retail sector face, travel limitations, and then a couple other topics too. But we did get one question from one of our listeners about critical infrastructure worker designations. So I'll just throw that question out there, and whoever wants to field it, go right ahead. One of our listeners is wondering if those letters need to designate, employees by name, or is it enough to sort of state broadly that the employer is doing critical work?
So again, that's you can simply designate that on a website if you like and do it more generally, but from the employee relations perspective, right, I think that something that may not be required to be tailored by employee, it might be advisable to at least do it by classification of workers, why they are critical, and why you really need them to support your operations during this time.
All right, so we will touch on a couple other pieces of the executive order now. Probably one of the areas that got the most attention in this new stay-at-home order is the retail sector, certain retail stores, which Jim described earlier in the webinar, grocery stores, and certain convenience stores, certain pet supply stores, stores that are offering essential items to the public. Steve, do you want to talk a little bit about what the executive requires of these retail stores that stay open to the public?
Yeah, sure. So this is paragraph 11 of the new executive order. And so anybody who's operating a retail establishment should definitely take a look at that paragraph and make sure that you go through it. I'll give you an overview of it. Essentially, you've got to figure out ways to make sure that any lines for customers waiting to come in or at the cashier, you have to figure out how to do that by social distancing. There's some suggestions about having, you text individuals while they wait in their car before they come into your premises. So clearly, the goal here is to keep people, as far apart from each other as you can, while still enabling your operations. The second suggestion, of course, is to consider establishing a curbside pickup. And again, this is to try to mitigate the person-to-person contact. And then there are, for smaller stores that are fewer than 50,000 square feet, then the occupancy limit has to be 25% of the total occupancy limits that are ordinarily allowed. So you can only have a quarter of the people that would otherwise be maximum occupancy. So that's for stores less than 50,000. For stores that are more than 50,000, there are more requirements. This is the scenario in which the number of customers in the store at one time have to be limited to 4 people per 1,000 square feet of customer floor space. So that would be something. The way to do that, of course, is to monitor folks as they go into the store. and to only allow in a certain number of people. And we've seen quite a few retail outlets do this already, even prior to the order, to just make sure that the number of people inside the store are down. There's also a requirement for, and again, this only applies to stores that are larger than 50,000 square feet, but there are certain categories of goods that have to be cordoned off. And this includes carpet, flooring, furniture, garden centers and plant nurseries, and paint. So those are specific categories that the governor has decided to have cordoned off, at least in in-person retail establishments. There's also a requirement that these types of stores have to refrain from advertising goods that are not groceries, medical supplies, or items that are necessary to maintain the safety, sanitation, and basic operation of residences. Frankly, I think this is a provision that's going to be difficult to figure out exactly what it means, and probably difficult to enforce, particularly with respect to these large stores. And then finally, the last thing pertaining to these larger stores are that they have to create at least 2 hours per week of dedicated shopping time for folks who are in vulnerable populations. So these are folks who are over 60 and have underlying conditions. Again, this is something that many stores have been implementing voluntarily beforehand, but now it's part of the executive order.
And a lot of these provisions went into effect right away. So I think some of our retail store businesses in our community are wondering, with all of these new requirements, what's the risk of enforcement, and what should we be thinking about? What are the penalties that we could potentially see if we're not in compliance with these? Jim or Steve, would you like to address that question?
Sure. So the enforcement mechanisms for the order number 42 are the same as for order number 21. And we have to also keep in mind that there was an intervening order from the Department of Health and Human Services. So willful violations of the order can be prosecuted as criminal misdemeanors. And under the Department of Health and Human Services order, there can be a civil infraction with a fine up to $1,000 per violation and potential licensing activity. And so the governor and the director of the Department of Health and Human Services really want people to take these orders seriously, and they have enforcement mechanisms in place for willful violations of the orders.
And maybe it's helpful just to outline kind of what we've seen, the process so far, what it has been. So typically, what happens is that the enforcement here has been delegated out to local law enforcement. And so part of this is that how active enforcement is and how they interpret the particular executive order and compliance with it. Part of that's going to depend on your local law enforcement officials, including the local prosecutor. So what we've seen happen is that folks, if there's a complaint or an inquiry made about a specific company, then sometimes a law enforcement officer will be dispatched and to go to the premises and to talk with the manager or owner and just kind of figure out what's going on. That's been one way we've seen this happen. Then they have discussion. Again, this is where the documentation very much helps to give an answer and an explanation of why exactly your operations are what they are. And then typically what happens is that the law enforcement officer, it communicates with the local prosecutor, and they try to understand kind of whether there's a good faith basis for this particular operation to be continuing, whether it falls within the order or not. And depending on what happens there, they usually say, yes, thumbs up, you're good to go, or you may have further communication with the prosecutor. And this may result in a cease and desist letter from the prosecutor, or it may result in a communication between your attorney and the prosecutor, again, to more fully explain exactly what's going on and why your operations are critical infrastructure, how you're abiding by the executive order. And that's typically what we've seen so far. I will say that the enforcement efforts on the east side of the state have been a little bit more aggressive than they have been on the west side. I think that reflects, the spread of the virus on that side of the state to some extent. But that's the overall process that we've seen. I haven't seen any criminal activity yet. We're still on the stage where folks are sending letters back and forth.
Right. I do think in West Michigan, at least, the emphasis has been on education about the terms of the order, what it requires, and less on citations being issued. It's primarily been education and gaining compliance rather than trying to take enforcement action through issuing citations.
Rebecca, I know we were talking a little bit earlier, actually, before this webinar got going, about enforcement actions and the potential for penalties and the risks that businesses have been taking into account. Do you have anything to add here on, what you've been counseling your clients on when they're thinking about the potential for an enforcement action and the disruption it could cause to their business?
I don't think there's anything employment specific other than, your thought process and your reasoning has to be consistent. And this goes to one of the questions I think that came in through the Q&A from one of our listeners too. The question basically was, we have determined that our workers are critical infrastructure workers, or at least the ones we have so designated, but we're getting pushback from the employees. How do we deal with that? Obviously, if you have law enforcement then knocking on your door, suggesting that you're not critical infrastructure employees, that's going to undercut your legitimacy with your employees. So this is an area, like everything, where careful preparation will pay off in spades later. Like you all just said, the documentation of the reasons, but we just have to be, you have to think through very carefully why each employee on site is a critical infrastructure worker, and communicate that to law enforcement. Hopefully it's been documented, like you all have said, but also you really need to work hard on communicating that to your employees. And when communicating to your employees, in my opinion, it's very important to include mission, right? And mission-driven organizations tend to do better in these sort of stressful situations. So not explain it like a lawyer would, although you can definitely include our explanations in your communications. But as we mentioned earlier, when you talk to your employees, also include why their work is important to the community, right, to the state, to the country, to however your organization fits into that. It can't just be so we can still make a profit this year, right? That's not going to go over very well.
I think we should touch on briefly, at least, the travel limitations that are in this latest executive order. Jim, would you like to briefly discuss what new travel limits are set by this executive order that just issued on Thursday?
Sure. So one of them that's new is a restriction on travel between in-state residences. So this order was issued on the 9th, and it prohibits travel between in-state residences. So in other words, if you've got a cottage in northern Michigan or a cabin somewhere, you, under this order after April 10, are not allowed to travel between those two residences. There is no restriction on travel from, let's say you've got a family member who winters in Florida or vacations there for part of the winter. Those people are allowed to return to their residences in the state, but there is a restriction on in-state between two residents travel.
Steve, anything? Oh, go ahead, Jim.
Well, I was just going to say, I have heard that in northern Michigan that there were stepped up enforcement efforts because there was a concern about people from downstate traveling to northern Michigan to get away from, I guess, some of the hot spots for the spread of COVID-19, and to try to do that by getting away up north. So the executive order also restricts travel to vacation rentals, but it allows people to return home from outside the state or to leave the state for a home or residence elsewhere.
Yeah, I'd like to, follow up on that. I see there's a question that just came in asking about what if the travel between the residents, there are two residents within 10 miles of each other. I think technically that's not allowed under the order. That seems to be what the order indicates. And there's a catch-all provision here, and I think it's paragraph 7, that says all other travel is prohibited, including all travel to vacation rentals. And to Jim's point, what's been very interesting about this order and the kind of discussions around it are the ways in which different parts of the state have reacted differently. Again, we've heard things out of northern Michigan, some suggestion that they'd prefer folks not travel up there because they do have limited medical resources up there. And to the extent that there is a kind of a virus that has significant, counts of cases up there, that can be very difficult for their, just given their particular resources. And so that has been an issue. I know there's also been, some pushback in West Michigan where the case numbers are lower than East Michigan. My understanding is that there was a task force that was set up by the Michigan Senate to address some of these issues and kind of think about ways to make maybe a more nuanced approach to some of these issues. And Amy, I don't know if you have the latest intel on that, but I don't know. I don't have the latest intel on that. I'm wondering if you do.
Sure. So I think what we heard last week, this was the same day, I guess Tuesday, when the legislature passed the resolution to extend the state of emergency declaration, which Governor Whitmer had requested. And they, the legislature didn't extend it so far as Governor Whitmer wanted, which was into June. The legislature only extended it through April 30th, so through the full month of April. In passing that resolution, the Michigan Senate announced, almost simultaneously, the formation of a bipartisan task force. And that task force is made up of members of the legislature who are going to take steps to make recommendations to Governor Whitmer on ways to maybe relax the stay-at-home restrictions, especially with an eye toward businesses that could safely reopen and maintain in-person operations, but maybe don't fit comfortably within the critical infrastructure designations. The task force announced that in making these recommendations, they're going to seek expert advice, go to health experts, go to public safety experts and discuss with them what sorts of concerns to have as they develop these recommendations. And they're also going to talk with businesses in the Michigan community, businesses that have been burdened by these executive orders, and talk with those businesses about, what steps they might be able to take to open safely. The thing to note about this task force is there's no guarantee that its work will result in some change necessarily. It will be an ongoing discussion, we think, between the task force members and Governor Whitmer's office. But there is this effort from the legislature to at least begin a dialogue based on some, the weighing in of experts based on businesses that they've spoken with. So a dialogue with the governor's office about, what sorts of businesses could we see opening again, and doing so in a way that continues to protect the public and continues to protect workers, and avoid or mitigate the possibility of increased transmission of COVID-19. The one fact we know is that the task force is planning to make recommendations to Governor Whitmer by April 17th. So that's Friday of this week. So I think we'll all be staying tuned to see what the task force presents to the governor, and then after that presentation, what Governor Whitmer decides to do with those recommendations, if anything.
Right. One other thing I would note, and that is helpful, Amy, that the governor in the executive order did say that she is going to be evaluating several different factors in deciding whether the order should be modified in any respect. And that was in the earlier executive order. It's also in this one. It says that she will evaluate the continuing need for this order prior to its expiration, and that she will consider, among other things, data on COVID-19 infections and the disease's rate of spread. Number two, whether sufficient medical personnel, hospital beds, and ventilators exist to meet anticipated medical need. Number three, the availability of personal protective equipment for the healthcare workforce. Number four, the state's capacity to test for COVID-19 cases and isolate infected people. And number five, economic conditions in the state. And so that will be a factor, I think, in the dialogue between the Senate task force and the governor. All of those five things, I think, will be.
In the last few minutes that we have with our listeners, I want to pitch it to you, Rebecca. Are there any questions that we received that you'd like to touch a little bit more deeply on, or big picture employment law issues that our listeners should be considering as they look to this new executive order and consider their steps for complying?
Yeah, thank you, Amy. First of all, I'd like to answer a question that came in through the Q&A function on the webinar, and then broaden the question a little bit to cover some topics that I think are on everyone's mind. The question is about a new hire coming in from Illinois, and what is the quarantining requirement before this employee can enter our environment. I am not aware of any quarantining requirement when someone is coming from another state before they can enter your environment. We always defer to the public health experts on these sorts of questions. And I know for those of you in HR, you feel like probably you've been designated a public health expert over the past month, but there are still county public health offices you can call and ask that question of. I am not aware of guidance from the CDC or from OSHA saying that that person has to be quarantined. But let's broaden that a little bit, because you should all be aware, if you're not already, of Executive Order 2020-36 that was issued on April 3rd, which already feels like a lifetime ago. That executive order says employees who have any symptom of COVID-19, symptom defined as fever, cough, or shortness of breath, or who have been in close contact with someone who has a symptom, must be allowed to stay home from work. And then depending on if it's symptom or just contact, there's different time periods there. So if you have a new hire coming in from Illinois, it's a very fair question to ask if they have any symptom of COVID-19 or if they have been in close contact with someone who is symptomatic of COVID-19, right? You can ask if they have a fever, cough, or shortness of breath. And if they do, they should stay home at that point. Other questions that have come in employment related during the webinar, I think I have addressed already. I see one on an immigration question. Frankly, that is not my area of expertise, but you can reach out to me right after this webinar at strauss@millerjohnson.com, and I'll connect you with one of our immigration specialists who will be able to help you with that.
Excellent. Thank you, Rebecca.
People have more questions.
Yes, and generally speaking, if we did not quite answer your question in the Q&A, feel free to reach out to us. Our names and contact information will be displaying on the screen right now. You can certainly look us up on the website if you don't have your screen up. Each of us, Jim Peterson, Steve van Stempvoort, Rebecca Strauss, and I are all on the website with our contact information. I do want to just recommend one more time and promote our webinar tomorrow, Tuesday, April 14th at 8 a.m., which is going to go into great depth about the COVID-19 preparedness and response plan that Rebecca highlighted this, a little bit early in our webinar. I think that will be, for many businesses who are continuing operations, that's the single requirement that is really new and requires a little bit of thinking on your part, whether you've got that plan already in place, whether you need to do something to make it comply with the requirement in the order. If anyone has any final thoughts, please chime in, and then we'll sign off.
Yeah, I guess the only thing I would say is that I know there's been a lot of questions in certain industries about whether certain operations count as critical infrastructure or not. And we've seen a lot in the news recently about nurseries and greenhouses and garden centers. And I guess I would just say, number one, a lot of that depends on the particular operations that are undergoing. Not every nursery is the same. They don't all have the same products. They don't have the same activities that they're engaged in. And the executive order may permit some of these operations to be continue to be conducted. That obviously is a fact-dependent discussion and inquiry, and it depends somewhat on the extent of the relevant CISA guidance as well, whether your operations fit within that. But I do want to encourage folks who may think that they're up against a wall, to look carefully at the guidance and to give us a call if you have any questions about whether it applies. Keep your operations open, because there may be some flexibility there that may not be immediately apparent.
Yeah, I think Steve's exactly right on that. There often is some flexibility that companies may have to maintain more of an in-person operation than what is apparent at first blush. And we've walked many clients through that, over the last several weeks, including under other states' executive orders.
All right, with that, I think it's time for us to sign off and let everyone get back to work. Thank you for listening to our webinar, and we look forward to working with you in the coming weeks as we continue to deal with the many issues that are, complicating things, and hopefully help smooth out those issues for you as you maintain your business operations.